Present sense impression. Present sense impression is one of the exceptions of to the hearsay rule. Meaning is, if a person made a present sense impression statement, anyone who heard the statement may come to court to testify about this statement. What do we mean by present sense impression statement? Present sense impression statement is a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition, or immediately thereafter. Actually, to state it simply, that simply means if a person made a statement while the person was perceiving this event, that is what we mean by present sense impression. We can look at this example, and now we know in this example we have this Adam and Bill. They were in a car driving on the highway, and then there was a car driving very fast passing by, and then Adam just commented on the car passing by, and Adam just said, "Look at that car. It must be driving at 90 miles an hour." So this is what we mean by present sense impression statement. While Adam was perceiving the car driving by, and then he made this statement, "Look at that car. It must be driving at 90 miles an hour." So this is what we mean by this present sense impression statement. So we have this present sense impression exception. Why do we create this exception? Because we believe we have circumstantial guarantee of trustworthiness of Alan's statement. Alan was perceiving the car while he was making the statement. So at that moment, while Adam was seeing the car pass by and he made this statement, "This car must be driving at 90 miles an hour," under the circumstance, we believe there is no reason for Adam to lie about it. We know in this present sense impression statement, because of this spontaneous nature of the statement, it is unlikely the person who is making the statement would tell a lie. Because we know when a person wants to tell a lie, usually the person needs to have time to think about it, to reflect, and to think why he needs to tell a lie and what kind of lie he's going to tell. But in this present sense impression statement, while the person was perceiving something and then the person made a statement, there was no time and also no reason for the person to tell a lie at that moment. So we believe in this, if a person made this present sense impression statement, we believe we have this circumstantial guarantee of trustworthiness. We can be positive, most likely the person would not lie. So we would admit this present sense impression statement, even though this statement is a hearsay. In this kind of situation, in this case scenario, just to say the person who drove this car at this 90 miles an hour, suppose later on he just caused an accident, and if the person now is on trial for reckless driving, and then suppose Alan is not available, and then the evidence law issue is, can Bill go to court to testify about Alan's statement? The answer is yes. Bill can testify as to Alan's statement. We know this Alan's statement, if offered in court, would be hearsay, because that would establish the car was driving very fast, was exceeding the speed limit. We know the person now is on trial for reckless driving, so this statement is offered for its truth. So it is hearsay. But nonetheless, Bill can testify as to Allen's statement because Allen's statement is a present sense impression statement. Under this exception, Bill can testify as to Allen's statement. Another exception we want to discuss is excited utterance. It is said excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress or excitement caused by the event or condition. So if suppose and we have this Nancy and Alice, and they were standing at this intersection, and then if they witness a car actually run a red light and cause an accident, and say Nancy made a statement, and Nancy said, "Oh, look at that car! Just look at that red car! Just run through this red light and caused this accident." And then, of course, if Nancy made the statement, Alice heard the statement, and then this Nancy's statement would be considered a statement of excited utterance. And then later on, if Nancy is not available, and then Alice actually can come to court to testify about this statement. The circumstantial guarantee of trustworthiness of this excited utterance is also because of this condition under which the statement was made. We believe it is unlikely the person, the declarant, would lie. So we know in this, if a person is made a statement because of this stress and excitement caused by this startling event, it is unlikely the person at that moment would tell a lie, because this once again, when a person is under stress, and if a person is scared, the person is in a very excited state of condition. It is unlikely under those kind of circumstances the person would tell a lie. Because once again, if a person is going to tell a lie, the person needs time to reflect, and so that he could fabricate a lie. It is not if, say, we have this car collision, or we have this big explosion, and under this stress of this all this excitement caused by this startling event. Under those kind of situation, it is very unlikely the person would tell a lie. So that is the reason why we say we have this circumstantial guarantee of trustworthiness of this statement of excited utterance. So if we have this, if a person made a statement of excited utterance, that statement would be admissible. It is important for us to know this excited utterance is different. The circumstances under which we apply this excited utterance exception is different from the circumstances we may apply the exception of a present sense impression. We know for this exception of a present sense impression to apply, the requirement is the declarant had to make this statement while perceiving the event or immediately after this event. It cannot be. In this previous example, we know this Alan and Bill, they were in the car and driving on the highway. They saw this another car passing by driving very fast. If Alan made the statement right away to say, look at this car, it must be driving at 90 miles an hour, that statement would be admissible under this present sense impression. But if I say an hour later, Ed and Bill, maybe they arrived at their destination, say that is just a stadium, maybe they were going there to watch this football game, and then an hour after they saw this car, and then Eden would comment, say, do you remember the car we saw on the highway? That car must be driving at 90 miles an hour. And then that would be not admissible under this present sense impression, because that was not a statement made while Eden was perceiving the event. Why we would require that? Because we know if there is a time interval in between, and then the motive to lie may arise. So we would not permit the application of the exception anymore. But in excited utterance, we do not require the statement must be made right after this startling event. If there was a statement made right after or while the person was perceiving this startling event, that would qualify as an excited utterance. But in excited utterance, we do not have this requirement that the statement must be made immediately after this startling event. The requirement is, so long as this statement is made when the person is still under the stress or excitement caused by the event, the statement would qualify as an excited utterance. For example, if we have this a person being assaulted, and then because of this assault, and then the person maybe lost consciousness, and the person could be in coma maybe for 2 weeks, and then after 2 weeks the person came to, and then when the say the police actually showed the person, asked the person about the event, and or maybe showed the person a newspaper report about the event, and then the person became very excited, and then because now the person actually remembered what happened, and then the person would make a statement in a very excited condition, and then that is still, and his statement would still qualify as excited utterance, even though this statement was made 2 weeks after this startling event. So in that sense, we know this under this excited utterance exception, even though the statement was made sometime after the startling event, so long as when the person made the statement, the person was still under the stress or excitement caused by this event, and then that statement would still be admissible under excited utterance. So for that reason, and then this excited utterance actually is often used in this child molestation cases, and in the chapter we do have this real case, and then there was a child molestation. There was a child molestation case, and a child was being molested over the summer, but it was not until October, and then the mother actually learned about it, and then the mother actually questioned this little child, and then the little child was crying, became very upset, and she told her story as to how this molestation happened. So even though that was several months after the event, the little child's statement would still qualify as excited utterance. So in that case, the mother actually could go to court to testify, to repeat whatever she heard from the child about this molestation. The mother's testimony about this child's statement would be hearsay, because it is offered for the truth of the matter asserted in the statement, but the statement would be admissible under excited utterance.